There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. If the Shiv Sena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, I said to your lordship the consequences of it. Supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of 6 of these people reduces the chief minister to a minority, therefore call for a floor test. It would be disastrous for democracy. That's the Ayaram principle that we gave up. Would 50 members of BJP today support Uddhav Thackeray, will he call for a test? So the whole propositions, the propositions that have been advanced by my learned friends are all contrary to basic principles of constitutional law. And your lordships have now read all the documents till July the 4th. Is there any reference to any split? No reference. No mention of split. When I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the house and outside the house, I continue to be a member of that party and must honor the discipline that's imposed on me. So, in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the house. Now, he can have dissent outside the house, but no dissent within the house, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it, constitutional rationale for it. Then, a fortiori, therefore, the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. I go back, to my submissions. So, para 20. Therefore, the recognition of a faction of a legislative party as the basis to cast a doubt on the confidence enjoyed by the government in the House would be an act of constitutional impropriety and legally malafide. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution. And kindly see sub-article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members, chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. Now kindly come, let's go to item 2. Under 7.1 of the Representation of Peoples Act 1950, the total number of seats in the Legislative Assembly of each state is as shown in the second schedule. Further, Section 7.3 of the Act provides that the extent of each assembly constituency shall be as determined by the orders of the Delimitation Commission made under the provisions of the Delimitation Act. I don't have to read it, your losses may take it that that's correct. We'll waste time otherwise. Then come to 4. The first step in the process of nomination, Section 33 of the Representation of People Act, prescribes that each candidate desirous of being elected to a seat is required to deliver to the returning officer a nomination paper completed in the prescribed form. The provision itself differentiates between candidates set up by a recognized political party and those not set up by the party. That's Section 33. No, let's not read it. That's up. Nobody can doubt what I have said. So otherwise, it'll take time. Next, the relevant rule in the conduct of election rules pertaining to Section 33 is Rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the Assembly is Form 2B. Part 1 of Form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in Form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, Section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Melissa. Kindly see that, 67 of the...
That's okay. I think, you've paraphrased it and there's no reason to doubt it.
Right. The reason is, what he sends is that he has been elected as sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Then, Malats, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So, Malas, he should have assumed that they continued to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left they say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the House and the strength of the number of parties in that House, or the strength of the party in that House. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget the majority. This can happen where 2 or 3 or 4 members of each political party can do the same. What you're doing is, when there was no 10th schedule, what used to happen? The same thing. What my lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified as a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Maharaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission.